Thanks, Justin. And on behalf of Berkeley Judicial Institute and our partners, the Civil Justice Research Initiative, welcome to all of you. We're so happy you're here to talk about the book Unjust Debts. I hope you will forgive a quick Berkeley Judicial Institute advertisement before we get started. Now that we have you here, whether you're here for the first time, as many of you are, or whether you're one of our cherished regulars, we'd love to see you come back. Check out our website where you can find registration links for future programs, recordings of past programs. Join our mailing list so you can be kept up to date on programs like this. Follow us on social media. Advertisement over. And Justin will put all of those links into the chat because I know you're going to want to follow up on all of that. So we are so gifted by the bankruptcy gurus you are going to meet today. Our moderator is Professor Abbye Atkinson. She teaches at a little law school called Berkeley in beautiful California. And her research areas are extensive and include bankruptcy and consumer law and protection. She'll be in conversation with Melissa Jacoby of the University of North Carolina Law School. Professor Jacoby, among her many talents, is the author of Unjust Debts. So welcome, both of you. Welcome to our wonderful audience. And Professor Atkinson, where will we start today?
Thank you so much, Denise. Thank you for preparing, getting us together to talk about this excellent book, Unjust Debts by Melissa Jacoby. I want to, take a moment just to say it's such a privilege for me to be in conversation with you, Melissa. You are someone who is, in the firmament of bankruptcy law, and as this book really shows, not just consumer bankruptcy law, but business bankruptcy as well. And one of the wonderful things this book does is to marry those things in really important ways. So welcome. And why don't you start by giving us a summary of your book?
Well, thank you for that very nice introduction. And thanks to everybody who's joining us now and those who might watch this in the future. So let me start a summary in a particular way by saying that I wrote Unjust Debts for a general audience. And bankruptcy's thought of being somewhat specialized. So why on earth would I do that? Well, bankruptcy is the busiest federal court in America, and I really wanted to communicate with a broader audience about the system. The system really affects things everyone cares about, including but definitely not limited to their wallets. There's a lot more going on here than money, and that's a theme in my research, and I think Professor Abbye Atkinson's research as well. Bankruptcy is really plays an important role as a safety valve in our society where households bear so much risk, including for events way out of their control. So my aspiration would be that the book would be accessible to people, meaning affordable, more so than some academic books, and also my dream that it lives in public library collections. Of course, none of that answers why anyone would actually read this book, Unjust Debts. So what I wanted to do was to tell stories and do an exploration rather than have a book of arguments. So some of the stories include talking about a woman who testifies that she's applied for over 1,000 jobs trying to stay afloat in the midst of the financial crisis. We have a corporate restructuring lawyer comparing his fast fashion Chapter 11 to sending a man to the moon. We have a long road for civil rights claimants who say they've been harmed by the Detroit police or others in Detroit, who have a long road to collect pennies on the dollar after the bankruptcy case had been confirmed, and most people went on to think about other things in our world. There are a few stories about me, including how I almost didn't take a bankruptcy class at all.
That's a good one. I love that one.
We might not be here today. No thanks to what was going on that rooftop at TGI Fridays. And there are some stories about ice cream, which I use often in my classes with students as well, that you can teach a lot about commercial law and bankruptcy through stories about ice cream. Let me also mention, in terms of these stories, something non-intuitive about bankruptcy that goes to the politics. Historically, so much bankruptcy legislation is bipartisan. And when cases go to the Supreme Court, they don't break down on traditional ideological lines. And that makes it interesting and maybe opening some doors for more discussions. So let me tell you a bit about the themes of this book. Now, early in my career, when I was first thinking about bankruptcy, both as a staff attorney to a government commission and then early as a law professor, I often did see bankruptcy as a lens to examine problems in other laws, in other sets of policies, because it forms this sort of diagnostic test of what's going on elsewhere. What kind of problems do people bring into the bankruptcy system? Over time, I worried that bankruptcy in practice not only reflects problems elsewhere, but is contributing to those problems. And that sometimes bankruptcy is at odds with its core mission and is undercutting policies that are really far removed from debtor-creditor law. So some themes in the book are about inequality, particularly race and class. I got very interested in federalism, not emphasized in the title or subtitle, but there is a theme there. Also, rule of law, really interested in how powerful interests want more from an already significant bankruptcy system. They want more advantages and extracting them, and that takes away from the intended beneficiaries, really unbundling the checks and balances of the system. And then there's the range of other policies that are affected: public health, employment discrimination, environmental issues and climate change, product safety. We could go on. This happens in part because the drafters of the bankruptcy code opened the door pretty wide in defining debt and claim quite broadly. So there are not a lot of spoilers in the book because it doesn't have a definitive ending. There's not meant to be a reform blueprint here. I aspire to start more conversations among more people. I do, because you have to finish a book, include a range of macro and micro suggestions. Ultimately, though, I should say I take a narrow view of the national bankruptcy power when all is said and done. I think it would be more effective at the core mission. I believe it would more effectively promote equality or reduce the contributions to inequality and the unintended consequences for other policy areas. So I'm really excited to hear Abbye's thoughts and questions.
Yeah, this book has so many virtues. You do so many things so wonderfully in this book. Perhaps most significantly is inviting everyone into our world of bankruptcy law in a way that makes it accessible and really does what you've described, which is to highlight the ways in which so much that matters to our society, not in the lens sense, but is reflected in bankruptcy, but that bankruptcy policy also is perhaps taking on too much, or bankruptcy practice, I should say, is taking on more than it should. Something you say early in the book, something you recognize early in the book, is our tendency in our market society to reduce all kinds of obligations to a dollar figure. Add that to a bankruptcy code that defines debts very broadly. We have invited all sorts of money obligations that stem from not just consensual or voluntary contracts, but tort liability, for example, as we'll talk about more later, into bankruptcy. So I'm wondering if you could start by, I find your sort of evolution of understanding what is bankruptcy for so fascinating. What do you think is what should be bankruptcy law's principal mission? such that the range of issues that you bring to the fore in this book can at least begin to be mitigated if we could try to understand what bankruptcy should be doing.
I think bankruptcy's superpower and what it's uniquely equipped to do is to cancel or modify debts for humans. I think that's obligation number one. We have a bankruptcy clause in the Constitution. It is something that states can't do. And there is a role for that in especially our increasingly complex economy, and the same economic arguments that are so often applied to the business world about why we need companies to go forward really can be applied to the human circumstance as well, in addition to the ability of canceling debt to reduce suffering and to promote other opportunities for that family. But I think we can also look at it in a broader lens, as many economists have, of the broader advantages to that. When we, of course, we have to marry that with treating creditors fairly and equally when to the extent possible. And that, of course, should not wane. The issue is, for the vast majority of people who use bankruptcy, they can't pay. And the amount of money it takes to try to come up with a situation where they might pay something, it might cost more than $1 to collect that dollar. So given the status of people who are in bankruptcy over the last several decades, and there are really rich empirical studies of those family circumstances, it can be hard to make sure that there's a stream of payments for prior debts that can go forward while a family has to honor everything else. That doesn't mean that creditors' rights are irrelevant. That it certainly means that the system needs to look fair and seem fair in addition to actually being fair. So I think that absolutely has to be part of the equation, and that it especially becomes part of the equation once we talk about the more complicated uses of bankruptcy and how we can stretch it to do more.
Right.
But those basic debtor-creditor relations, especially involving borrowed money, I do think
At
as
the core
as the
of
root
what
of it.
bankruptcy should be doing. So that leads me, I love that, into, the next question I have for you. You distinguish bankruptcy for real people, humans that you've just, referenced as being core to the bankruptcy power, versus bankruptcy for fake people, namely the persons in various laws who exist as creatures of law and not as natural human beings. And what I find interesting is that in the fake people context, the real people are creditors in the fake people context. And I sense throughout your book, I mean, your book is, in my view, very humane in thinking about how debt relief affects a range of stakeholders, creditors, debtors alike. So should bankruptcy, across consumer bankruptcy and business bankruptcy, think about real people and fake people the same way? I should say real debtors and fake debtors, fake filers, real filers. Is there some even ground we can discern or begin to think about in terms of how we should be treating real people versus legal people?
Let me respond to that by first saying where I think the system is today, which is a system that treats big corporations way more generously than financially distressed families.
Yeah.
And the rationale for that is underdeveloped. If anything, I think there would be stronger rationales to prioritize the more generous treatment of humans. And let me also say now, given my focus so far and the terms fake and real people, this book does not call for the end of chapter 11. I think especially for small businesses, it's an incredibly important tool. So once we go past the foundation and build on that, we see that many humans and communities and economies can benefit from some reorganization structures. And I don't use the term fake to be pejorative, although I understand some people see it that way. It is shorter than saying business, nonprofit, city, etc. Each time. But fake people can be created over and over and over again, and they bring limited liability. And so one would think there would have to be more of an argument to give more protection to fake people. And I think we do have to recognize that even what I said before about the role of bankruptcy in canceling debts and restructuring them, that is a major aberration from the rest of our law. So what special and extraordinary rules of bankruptcy should be available to any kind of person is something I think people outside of our world might wonder. And maybe we don't wonder about it as much inside the bankruptcy bubble, so to speak. So I do have a lot of concern about that question, even though I don't have answers. So let me just point out some of the ways that fake people are preferred to real people in bankruptcy law, especially big ones. A lot of it comes from statutes and appellate court, Supreme Court decisions. We got the timing of debt cancellation, the scope of debt cancellation, the level of oversight, the ability to select one's court in various parts of the country rather than where one lives. Other aspects come from human psychology and implicit bias and the way that we have value judgments about humans and the way they might conduct themselves that don't always translate when we're talking about the cases with the biggest number of dollars at the end and the lawyers with the nicest suits and shoes. So that's where I'm coming from on this question. So I don't necessarily think they need to be treated exactly the same, but I am questioning the preference that I try to track in Unjust Debts, whether we can rethink some of that and come up with some better rationales for it.
So on that note, I want to, so let's dig, perhaps get a little bit of, little weedsy here to think about, to flesh out some of those ideas. As someone who has thought principally about consumer bankruptcy and much less about business bankruptcy, or Chapter 11 more specifically, your book was an entree for me into the world of, the current high profile Chapter 11s that are sort of floating around and more in our national consciousness. And so we could, certainly there's the Purdue bankruptcy and the Sacklers and, related, of course, to the opioid epidemic and the Supreme Court's decision recently. I want to come back to that. But or we could talk about Alex Jones or Rudy Giuliani or 50 Cent, right? These sort of big cases where we see wrongdoing being the consequences of wrongdoing, of tortious behavior, more specifically, being dealt with in bankruptcy. But I want to focus on the Johnson & Johnson case. And so just by way of, floor setting, Johnson & Johnson makes baby powder. If you come from anywhere in the South and you're of a certain age, my family's Jamaican. Baby powder was ubiquitous in our household. Turns out talcum, I should say specifically talcum powder, talc is contaminated often by asbestos, which of course is a carcinogen. And so fast forward, there are a host of people, women specifically presenting with ovarian cancer. There are other sorts of cancers that have come up. And so Johnson & Johnson is on the receiving end of various tort claims, and some of which have already been adjudicated in the various courts. And so Johnson & Johnson has been trying to get into bankruptcy, short and dirty summary, trying to file bankruptcy to deal with their tort liability. They have engaged in this Texas two-step at some point, which relates to Texas's willingness to recognize various, I don't know, limited liability entities being formed. And so Johnson & Johnson carves off one entity, they throw all their liability into it, and they're trying to put that entity into bankruptcy. The Third Circuit recently rejected Johnson & Johnson's attempt to file, or should affirm the bankruptcy court's rejection of the filing. And part of that opinion, as it relies on the bankruptcy court's decision, is that there's no financial distress, right? That the J&J's entity couldn't establish that there was a need for reorganization, a real need for reorganization. And part of that, I went back to the case, the opinion, to look more closely. And one of it is that the entity that's supposed to fund the bankruptcy filing entity could liquidate itself, and its liquidation would cover the all of J&J's potential liability. And that's all to say, it sounds to me like a means test. It sounds like a version of the means test. And we know that, those of us who think about bankruptcy, that, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, the big sea change in consumer bankruptcy law, introduced a means test that sought to kick out families from Chapter 7, right? Principally, and to, in effect, prevent them from getting a discharge insofar as the Chapter 13 filing is more difficult and success rates are much lower. So that's all to say, understanding your point that, we shouldn't necessarily think about the big business bankruptcy, or and I hesitate as well to characterize J&J as being, equivalent to all big business bankruptcies. They're doing something very specific. But should we be means testing? If we should be means testing individual filers, do you think the Third Circuit's opinion stands for this notion that maybe we should also be means testing corporate filers, if that the abuse issue is present potentially across all bankruptcy filings, if we're worried about the core purpose, reorganization of a particular kind?
There's a lot in there that we could unpack. Let me take a couple strands at that and see what I can do. So first, to set the stage, some of the people who are in this webinar right now live this, others may not. The vast majority of businesses that do file for Chapter 11 don't look like the biggest of one of the world's biggest and most profitable pharmaceutical companies, who creates a company to contain only its liabilities and to pay everybody else, and not women with ovarian cancer. And especially, again, so many are small businesses, and Congress, on a bipartisan basis, recently made some important steps to make bankruptcy more accessible and feasible to reorganize small businesses. And the reports are that that was a really effective, important thing to do, at least from what it looks like right now. So we want to start with that. Then beyond that, we do get back to that question of bankruptcy is the emergency kit. We have laws that ordinarily apply.
Yeah.
Who gets to go in and use the emergency kit? Now, in general, we do see exceptions of wealthy individuals who might try to abuse bankruptcy, but for the most part, we have decades of experience because bankruptcy especially is so complicated and expensive, but even if it wasn't, that families do everything to try to stay out of bankruptcy, and indeed wait a very, very long time, simply because it's, nothing simple about it, but in terms of the stigma of it, the embarrassment, believing they are supposed to find their own way out, and then the expense of it, and then the alienating sense of the law and how whether people view their problems fitting a particular legal mold. So I think that's important to say. On the business side, there's always been a sense that, well, bankruptcy can offer a set of strategic tools, and fake people don't bear stigma the same way. Bankruptcy is very expensive in Chapter 11, very expensive in the biggest cases, as claimants in big cases watch the bills that the professionals charge for those cases, so they're expensive that way as well. So I don't mean to make it sound that it's easy, but it fits better into the idea of a lawyer advising a corporate client about their various strategic options. So I guess the short way of saying that is, if J&J can do it, can't anybody do it? Use the emergency kit rather than the general rules. That's because, so Chapter 11 is filled with benefits for companies and related parties that really shift the leverage and push toward getting a majority to get on board and then forcing everybody else to go along. And we don't see that in other parts of the law. So putting aside where I'm currently sitting in the Fourth Circuit Court of Appeals, which makes it very difficult to remove a Chapter 11 case from the bankruptcy system based on law from decades past that look very different than these cases. Most circuits do have tools to say that companies don't belong in Chapter 11. They're not frequently invoked. I'm not sure that there's great empirical research on that. And they lay out a variety of different ways that someone could make the argument that a company is in bankruptcy for not the right reasons. The Third Circuit, which is where Johnson & Johnson was its first two times, had that law on the books. And in that talc bankruptcy, the court did choose to focus on lack of financial distress rather than arguments like questionable motivations or what's a valid reorganizational purpose.
Yeah.
And so I think it had multiple options. It did choose financial distress because of what you and I both know, and many in this group know about how individuals are treated. It doesn't seem shocking to say that businesses shouldn't get to use the special rules of bankruptcy unless they're in financial distress. Congress intentionally did not put an insolvency test in Chapter 11. It did put that test in municipal bankruptcy. And there are arguments about whether that's right or wrong. So that leads to financial distress being a more amorphous test than some sort of strict insolvency test. But if commentators think it's wrong to block a company from executing this strategy because of financial condition, or are worried about the broader effects of this opinion on Chapter 11 access, I hope those same people will take a hard look at the personal bankruptcy cases and advocate for some changes there as well. Again, coming back to what we can learn from looking across these cases.
Yeah,
So,
I mean, that makes a lot of sense to me. You and I have talked a bit about, 'cause that leads me to think about this principle of equity. So per our previous discussions, you sent me this really interesting case about the Gateway Pundit, in which who tortious defamation, stuff going on there, and is wanting, attempting to file Chapter 11 to reorganize, but really the decision hinges, as I read that as a bankruptcy court decision, dismissing the case, hinges on some of these principles. I have some of the wording here that I wanted to read, right? The court says, implicit in any good faith analysis is the question of whether the bankruptcy filing masks other less savory aims. And then also says that at its core, the question of good faith in a bankruptcy filing is an equitable one, which is to say that bankruptcy courts can see an opportunistic filing when they know it's there. And sort of the Third Circuit and perhaps in the Chapter 11 context, we see Congress more willing to give to bankruptcy courts that discretion versus the consumer context where we have codified a means test, a presumption of abuse based on a set of calculations. So do you think that that Congress should go back pre-BAP-CEPA to sort of give bankruptcy courts and the common law that has developed around abuse, that's the appropriate way? Like, if there should be any shift here, that the Third Circuit's opinion or other, opinions that have come down dealing with when a Chapter 11 filing is in bad faith, that we should apply that sort of latitude, that presumption of good behavior to individual filers and allow bankruptcy courts to recognize abuse when they see it in an individual filing. Do you think that's where we need to be?
I believe there's a good argument for significant structural reform in personal bankruptcy. In part, that's because the 2005 amendments to the bankruptcy code made it complicated and expensive in ways that are unevenly applied and don't have a lot of justification. One element of that arguably precedes the 2005 amendments, but was certainly exacerbated by it, are the documented racial disparities in what bankruptcy filers pay to get into bankruptcy and the kind of relief that they receive. Study after study has shown that Black bankruptcy filers pay more for bankruptcy relief and get less relief. And Chapter 2 of Unjust Debts documents those studies and the approaches that they took to get there. There are other factors, including research that you've done, Abbye, that also makes exacerbates racial disparities in personal bankruptcy. And I digress to this important topic because I think that even more than whatever effects the means test itself has had is really the more fundamental question here. I think you're raising a really important theoretical question. Well, actually, and also, of course, it's a practical question to say, if you believe there are boundaries on who can access bankruptcy, what's the best way to implement them and apply them? One benefit of crystalline rules, as some might say, is that we do have some experience with individual oversight of whether a bankruptcy is a substantial abuse. And we get a level of both non-uniformity, but also various biases that go into that analysis that could be of some concern. So I would say that these are difficult questions to work through. I think the Consumer Bankruptcy Reform Act that Senator Warren has proposed addresses some of these questions. Economist Rich Hines has a proposal that simplifies bankruptcy substantially, that at least somewhat could deal with these issues. But I don't think it's as easy as saying we want this to be a discretionary decision because of some of what we already see in bankruptcy land.
Yeah,
and in other legal systems. Let me just be clear. This is an example of it's a piling on, but it is not unique to bankruptcy in any way.
Indeed. I mean, I think that that's an important point that you make in the book and here is that is one related to sort of implicit bias, right? And so the documented the pernicious effects of implicit bias and how the work that it does, not just in bankruptcy, as you point out, but in other areas of law and sort of just our justice system more specifically. I'm trying to be mindful of our time and make sure there's some time for questions. But maybe, something that I keep thinking more and more about this, the more I think about your book, is this issue of limited liability. And I think that that's one of the important threads that illuminates the book. And who has the luxury of limited liability and who does not? That's one set of questions. But the work that sort of state processes then, if we understand limited liability as principally a creature of state process. What do you make of it, right? What do you think of the work that limited liability does in organizing obligations and drawing lines and cutting off and setting aside, pots of money and pots of assets? Maybe, again, too broad of a question, but if one of the issues in Johnson & Johnson glaringly and in other places is, in other bankruptcy filings, is the use of limited liability to deprive creditors of access to recovery. How is the J&J problem one of limited liability principally, right? And I want to offset that. I want to introduce the ice cream into the conversation and Ample Hills Creamery, that, not to use Johnson & Johnson as the only marker of limited liability, that might also understand a small business, the ice cream business, that you come back to think about why a corporate reorganization is useful in our society. So, maybe most broadly, like, can you share more your thoughts on limited liability and how it affects a recovery in a bankruptcy filing?
This is why I love talking to you, Abby. You make me think really, really hard. So I hope I have something useful to say here. So first of all, I do not think that the Johnson & Johnson situation is primarily an issue of limited liability. Limited liability is a very important tool for lots of different enterprises at various levels of development, and it does help people start businesses and organize their affairs in ways that can promote some flourishing. The key is that, and this is something that I've written about a bit with Ted Janger in an article called Tracing Equity. There's a family of other legal doctrines at state law, fraudulent transfer as an example, and that's one that we bring into bankruptcy, and that in these so-called Texas two-step cases or divisive merger cases is actively in play. It just takes a really long time to bring a fraudulent transfer action, or more likely to settle it. So I think we've got lots of doctrines piercing the corporate veil. We could go on and on to deal with some of those issues without throwing the baby in. I don't like the baby bathwater analogy, but you know what I mean.
Yeah.
I think we do have the tools to deal with those things. I think the Johnson & Johnson situation is more an issue of, well, one, I think there are a lot of issues. And again, they're not the only ones who have done this strategy, but they are the most prominent. There is a deep-seated, people raise a lot of concerns on the corporate side about personal injury lawyers and their practices. And a lot of the Johnson & Johnson briefing, including testimony to the Senate Judiciary Committee, including briefing to the bankruptcy court, was really briefing about their opinions of personal injury lawyers and trying to limit their effects. And there's a range of lawyers in all fields, and I'm not in a position to comment one way or another, other than to say we don't paint any industry with a broad brush. Right. I'm not going to paint restructuring professionals that way, or personal injury lawyers one way or another. So I think that's an issue. I think also once we have a toolbox that looks very handy, and bankruptcy looks extremely handy, like it can solve a lot of problems, there's a tendency to want to reach for it, to say, well, if we can get the majority of claimants to sign on, what's the harm of using the bankruptcy mechanism? And I can't answer that in the several minutes we have here, but that's part of why I wrote Unjust Debts, is that I think we have a lot more thinking to do about what the potential costs are and harms. And they're not always, they may or may not be money, but they are due process. They may be separation of powers. They may be federalism. They may be legitimacy of the system and perception of people affected by this system. Now, you mentioned ice cream. So let me just also mention that I do use the ice cream example, and Ample Hills in particular, a New York ice cream company, to demonstrate this, and it's something we also talk about in my secure transactions classes and other places, which is that limited liability doesn't only gives a shield when it gives the shield. In other words, when new businesses are trying to borrow money, there may be, if they're fortunate to have the founders are fortunate to be homeowners, they may be asked to put a mortgage on their home. They may have personal guarantees. And so the Ample Hills story demonstrates that, including with some tax responsibilities. So in the Ample Hills example, not only did the company file for bankruptcy, but the owners did as well. And they did not get a completely fresh start. They have a lot of responsibilities that will stay with them pretty much forever. So that's another reason I think we can't talk about it in terms of an all or nothing concept.
No,
But it is
that's
something
fair.
I don't doubt that bankruptcy should respect it. I don't think that's the issue, but those other doctrines and considerations also come into play here.
Yeah, I mean, I think, in some of these questions that I've asked you today before we go to questions from the audience, again, I said in the beginning that this book has many virtues, and one of them is, pointing out that our lives are messy, but bankruptcy and the trade-off between relief and the sort of bankruptcy as a system of redistribution is really hard. It's hard to think about. It's hard to draw concrete lines. It's hard, as you point out, to say something, bright line about limited liability, because the principles might be applied to, Ample Hills and Johnson & Johnson, the underlying state process, but the outcomes based on who they are, the resources they have at hand, are very different. I'll maybe before close, just an observation of something else I'd love that you said in the beginning is that, this book should be in libraries. My spouse takes my children to the library and they come home with all sorts of things. And I love the thought that they would come home with Unjust Debts and be able to understand it at the level they're able to understand. And then their mom, as a law professor who thinks about bankruptcy, will think about, issues in that particular very niche way. I think your book is wonderful because it really brings out the sort of human stories, even in and among the fake people, right? That it's all really, you use that distinction, but what comes out at the end is that there really is no distinction, right? That these are all issues, bankruptcy issues affect real people in all ways, shapes, and forms. So with that said, Denise, do you want to open up the queue for some questions for Melissa, for Professor Jacoby?
Not before thanking you. Whether someone is new to bankruptcy or experienced, how lucky are we all to learn from the two of you? So the first question, can you talk a little bit more about how the system is systemically unjust to vulnerable real people, and in particular to people of color?
So the examples that I give in the book focus on two scenarios. Systemically is a hard word, but I think we can do it here. So the primary example is in personal bankruptcy, to show the research that illustrates that over time, as I mentioned, Black filers are more systematically shifted into the more expensive and less effective kind of bankruptcy, which is called Chapter 13. I know that some out there will, Chapter 13 has some important uses in our system. I also have to acknowledge that even in light of those, the studies that we have suggest that Black filers do not achieve those benefits in the same way that white filers do, and that's controlling for all the variables that anyone might want to control for. In addition to this, both Abbye Atkinson, our professor here's work, and Professor Michelle Dickerson at University of Texas have, I think, shown that both on the debt side and the asset side, that the debts that are permitted to be canceled or not, and the assets that are permitted to be kept or not, turn out to be optimized for white families, as how Professor Dickerson puts it, on the property asset side. That is not written in the law. The law does not talk about race. It is mapping on the law onto how the system works in our real world. And this is why and again, this is discussed more in the book. I do give other examples of this is way more rare in our system, but in municipal bankruptcy and city cases, which tend to be in cities that already have records of police misconduct and high civil rights, a variety of civil rights challenges, that the way that those claimants are treated during and after the bankruptcy has a disproportionate effect on Black and Brown residents of those cities. I don't, in this book, talk about some of the employment discrimination cases that have come up in Chapter 11 in commercial cases where companies are sold free and clear of civil rights claims and what can come out of that. But there are examples of that as well.
Thank you. Going back and talking a little bit about municipal bankruptcy, are we likely to see a solvent municipality or county file for Chapter 9 just to discharge liability for mounting lawsuits, as you were just describing?
So I love this question in light of the discussion that Professor Atkinson and I already had, where we talk about the various gatekeeping levers that are put into the bankruptcy code by the drafters, technically by Congress. Municipal bankruptcy has a really interesting history that's different from personal bankruptcy, that's different from commercial corporate cases or even nonprofit cases. And what we see is that it went from a very narrow system that was only about restructuring bonds to something way broader, which leads to what I've already suggested. However, along the way, Congress, or the drafters of municipal bankruptcy, put in an express eligibility requirement that we don't find for businesses in Chapter 11. One of those is insolvency. Now, the twist there is that insolvency for a city is a little bit different than insolvency for a company because of what can be forcibly sold, et cetera. But those considerations have already been built into the law. That being said, that doesn't give me complete comfort on this subject, but I do, or resolution on that subject. But I do want to make clear that there is a solvency threshold, or insolvency threshold, I should say, that can be challenged by any claimant to stay in the bankruptcy process.
Thank you. And I'm gonna ask Professor Atkinson this first, and then give you a moment to pause, because it makes me think. I went to Catholic schools and over disclosure, and we used to always say, "Can God make a rock so big He Himself could not pick it up?" This is the question: could Congress give more discretion to bankruptcy judges that could not be abused? Give more discretion, can't be abused. Professor Atkinson?
I think Congress, as an actual matter, could they? Yes. They wanted to authorize bankruptcy judges to exercise more discretion than the existing code, as it's been interpreted, seems to do. I think this is a challenging issue for not just bankruptcy judges, but for any official who has the power to exercise discretion, right? Coming back to this notion that we live in a world of implicit bias. And so for example, the Lawless Browker Cohen study that studies how attorneys advise their individual clients about when and how to file, that Melissa includes in her book, and that attorneys of all kinds, of all sorts, of all stripes tended to recommend Chapter 13 to Black filers, similarly situated Black filers, and the presumption that Chapter 13 is the more onerous, burdensome, it's the repayment obligation. I think as with it, and so I guess I'm being careful to say that I don't think there's anything inherently worrisome about bankruptcy judges exercising discretion. I think anytime we authorize the use of discretion in any context, and certainly in something like bankruptcy where the stakes are so high, we have to also then, Congress has all to think about the sorts of guardrails we might put up to try to keep those sorts of biases out. My understanding, that said, I think bankruptcy judges are, widely respected as real experts in the work that they do. And my sense is that most bankruptcy judges become judges or are selected to be judges because of that expertise. So I think it would be fair to give more discretion where discretion is necessary, and then maybe on the back end, try to account for the sorts of things we would worry about, like implicit bias.
Thank you. And before I turn to Professor Jacoby, I will say I've been lucky enough to work with bankruptcy judges throughout my career. And if there were a group of people I would give endless discretion to, if I had a vote, I would vote for them. But Professor Jacoby, what do you think?
Well, there's so many ways one could take that question. I can't help but think of recent other Supreme Court decisions about the administrative state and the like. But we won't go down those paths. There's always going to be discretion for any group of judges at we'll call it the trial level. We do have an adversarial system by design. And so the question is discretion over what? And sometimes, I've had the privilege of working with bankruptcy judges and have great admiration for the bench. I started my career clerking for a bankruptcy judge in Chicago, which really, really changed my life. So I come with that belief in how great this bench is. So it is not about the people. It is about humans. It's about humans and the size of the question they're asked to deal with. If not in an adversarial process, what can they draw on to make those decisions? And I'll just end by saying that sometimes when the Supreme Court or Congress sets a firmer rule, that makes a judge's job actually less chaotic or less, there's more that they can do to help the process along because certain things have been taken off the table, and there can be value in that. But as Abbye said, I don't know of any preclusion of that model.
Thank you. And then there are a couple questions about systems. If you had a magic wand, what thing would you change if you could just change one? And are there other models we should be looking at, other insolvency models, England, somewhere else, something well, I shouldn't answer for you. Go ahead. What do you think?
So this question's a really interesting one because for so long, American bankruptcy law was portrayed as the model for everyone else. And while I'm not a comparativist, and I think it's very delicate to decide what kind of legal system should be in any other country in light of the other pieces of the puzzle, I think one thing we've seen is that we have a movement on the consumer side more to American style because consumer credit grew in other parts of the world. And in the business context, we probably have seen the exportation of Chapter 11, although now there are plenty of countries who would like to compete with Chapter 11. And if people aren't happy with the way they're doing it here, then Singapore will take the case, or Canada, or the Netherlands, or the like. So in terms of one question that I've been asked before that goes to this point is, should personal bankruptcy and business bankruptcy really be separated? And I think my conversation with Abbye suggests that that's almost impossible, not completely, but almost. But I think that question comes up because of showing just how much difference we have in the same system. Structurally, I do believe a more simplified personal bankruptcy system would be absolutely is very warranted, and it would be great if it could happen. And then other questions I think we have structurally is the scope of this system. Now, again, we have lots of micro things, but in terms of macro, what is a debt? What is a claim? Just because Congress made a choice in 1978 doesn't mean that always has to be. I'm not saying for sure it should be different, but that is itself. It sounds small, but it is a very big structural change to question those parameters.
Thank you.
I think, that's an interesting question as someone who, has written, the back end of the project is always, here's what we should do. We should, get rid of the means test or something like that. I mean, it's complicated. I think we, in the bankruptcy code, there is, section 523 that has a list of debts that are categorically non-dischargeable that in the past I have found to, be overly burdensome on particularly marginalized groups. And I wonder, it also plays with this question of discretion. Either we put more, ask Congress to be more specific about what, defining a debt more specifically, defining a claim in a case more specifically, defining a list of obligations or requirements, for example, before one, one of the points that Justice Gorsuch makes is that, Congress put in a procedure for asbestos filings, right, to deal with a particular mass tort, and if it wants to deal with, opiate mass tort liability, it should and can do that too. I quite honestly, I think the more I study these sorts of issues, the less sure I am about which way we should go. Do we shift for greater specificity, or do we go with greater discretion for bankruptcy courts to suss out the facts on the ground and to think about the valence, the equities, the facts of each particular case? I don't know. Quite honestly, I feel like it has to be case specific in some way, shape, or form. But given I looked this up recently, the sheer over 450,000 bankruptcy cases filed, and that's a historically low number. How do we as a practical administrative matter go about managing any sort of change from greater specificity to more discretion? I think it's a really tough issue, tough question.
That's why we count on wonderful people like you. So we have a barn burner of a last question. Any thoughts, Professor Jacoby, on the difficult bankruptcy situation in Houston, recognizing that everybody here is not a bankruptcy person? There was a judge with a judgmentally, I will say, huge ethical conflict, an undisclosed relationship that has put lots and lots of cases in question. Do you think that's systemic, individual, something different?
Oh, and it's 3:59.
I know.
Or 12:59 there. Thank you for the question. I know this weighs heavily on courts everywhere and other judges around the country, because it raises a question that is of great concern. I hope that the investigation is made as ultimately as public as possible, because I think a lot of people have been involved in the cases that have been implicated and would be helpful for closure and next steps, and how you can design systems that would be more resilient to these kinds of problems. But I think, to me, the reason it was so shocking is because it is not something I've seen in the bankruptcy system in a long time.
So I will give you an upbeat. I will say that one of the people who sat in on this conversation is an undergrad. And she said, listening to the two of you has reaffirmed for her that she wants to go to law school and she wants to study bankruptcy. So that's not a bad hour's work, do you think? And my unsolicited advice to that wonderful student is try to get into bankruptcy court as often as you can. Take a look and see what's going on there. Because I think people's native reaction when they hear bankruptcy is this is gonna be a pencil pushing kind of crowd, lots of green shit. And it's my experience, so demonstrated so beautifully by these two people here today, that it's an energetic, enthusiastic, intelligent, engaged group that wants to do good things. So thank you, thank you, thank you to the two of you. Thank you to my colleague, Justin. And I look forward to the next time I'm lucky enough to work with all of you.